I'm Dr. Jerica Cook, and I'm the co-chair of the NISDA New Dentist Committee. So I wanted to welcome you to the first session of our 4-part New Dentist Survival Guide series, setting yourselves up for success. This is important to me because as a former resident, former attending, former associate program director, I've always just been passionate about the things outside of dentistry that is very important that you know. And I think this is a very important one. And I think NISDA has done a great job putting this together to help you guys out outside of the clinical aspect. So tonight, attorney Matthew Feldman is going to talk about contract pitfalls to avoid and explain why all contracts are negotiable. Our goal is to help you feel comfortable negotiating for yourself before you sign your first contract or any contract during your career journey. I would like to welcome Matthew S. Feldman. He is a partner at the law firm of Feldman Kiefer LLP and represents business entities, including healthcare professionals and institutions on many different aspects of employment law. Mr. Feldman obtained a Bachelor of Arts degree from the University of Rochester before graduating from Columbia University School of International and Public Affairs with a Master of International Affairs and a certificate from Columbia's Middle East Institute. He obtained his law degree and a certificate of concentration in international law from the State University of New York at Buffalo School of Law. I can tell by the amount of tabs he has open on his browsers that he is one of the most hardworking people, which means he has to be very knowledgeable because he works extremely hard. So I assure you that you are in good hands. Welcome, Matthew. Excuse me, Mr. Feldman.
Thank you. Thank you so much, Dr. Cook. That is definitely my favorite introduction. And thank you all for joining. As Dr. Cook mentioned, this evening's presentation focuses on what we call professional service agreements. That may be an employment contract, it might be an independent contractor agreement, but professional service agreements are contracts through which licensed professionals like yourselves deliver services. And tonight's presentation aims to be both educational and informative, but also to provide you with a set of tools that will allow you to better read, analyze, and assess contracts that you'll be presented with soon and throughout your professional lives as well. We're going to distill this into contract terms that you should look out for, including terms that you should ask for in negotiations. And lastly, terms that you should never accept, or by all means, try your very hardest to avoid accepting. A brief disclaimer, our firm, Feldman Kiefer, is a private law firm that provides professional services to the public as well as to NISDA members. The firm and I have no actual or potential conflict of interest in relation to this program and presentation. Tonight's presentation is structured with first an overview of key terms and agreements in general, and then detailed listing and description of key contract terms to look out for, as well as key terms and provisions and revisions that you should ask for. And as I mentioned, contract terms that you should avoid at all costs. But before we begin, I think it would be interesting to start with what does the employer expect and require of you? And I don't simply mean in terms of your attitude and showing up and being highly productive. These are all expectations, but I mean specific requirements that you will find in really almost any professional service agreement. These requirements are often listed or specified as express warranties and representations of the employee. They're typically contractual conditions that must be met upon the effective date when the contract becomes effective and services are being offered, as well as conditions that must persist throughout the term of the service. Some of them are obvious. For example, you must have a valid and typically unrestricted dental license in New York State before you can provide services in a professional service agreement. Oftentimes, employers seek candidates with no prior disciplinary history. For most residents, this is not a factor, but oftentimes disciplinary issues arise during a career. This does not foreclose every opportunities. When there is a disciplinary history, it needs to be disclosed. When there's an express representation in a contract that says, I've never been sued or I've never been disciplined, if that does not correlate with the reality, it needs to be modified. It needs to be revised. Another core requirement that you will typically see in professional service agreements is a representation that you have not been excluded or debarred from any governmental payer program or plan. There are requirements that you are eligible or already participating in private and governmental insurance programs. Some contracts will require that you are eligible, have obtained, and or will maintain privileges at certain hospitals or institutions. Board eligibility or certification is sometimes a requirement for specialists. Another requirement that you will always see is insurability or eligibility for professional malpractice insurance coverage. The moment that that ceases to be the case, a contract will terminate. And lastly, as I mentioned, privileges or credentialing with third-party payers. As I mentioned, we call these types of contracts generally professional service agreements. And as I mentioned, not every professional service agreement may be an employment contract. It may be an independent contractor agreement. So one of the first things that you should assess when you receive a draft or proposed agreement is it a contract for employment or is it for an engagement as an independent contractor? And I'm going to discuss what the differences are and what the impacts can be. Other aspects that we want to see in a contract is that it is compliant with state and federal law. And professional service agreements for healthcare professionals must satisfy specific requirements, particularly when services will be reimbursed through any state or federal healthcare plans. Items 3 and 4 are obvious, but they're no less important than 1 and 2. Contracts should be fair. They should be reasonable. And we're going to talk a little bit about what a fair contract looks like. And review by counsel, again, this seems obvious, but in my professional life, I couldn't count how many times I've been presented with a contract when a person regrets signing it and it wasn't reviewed beforehand by counsel. So this is something very important and not to neglect. And it may create a small upfront cost, but the potential savings through going through that exercise can be very difficult to quantify. So starting out with proper classification of the professional. Are they classified as an employee or as an independent contractor? And is this contract for employment or an engagement? So the first question to ask is a person an employee or an independent contractor? And frankly, it depends upon a number of elements and characteristics of the engagement. Independent contractors, in contrast to employees, are free from supervision, direction, and control in the performance of their duties. We call them self-employed. They're in business for themselves, and they offer their services to the general public. Signs of independent contractor status include a person or professional who has an established business. In that case, the contract may be with their PC or PLLC, as opposed to the professional as an individual. Independent contractors often advertise to the public, use their own business cards, stationaries, bills, independently carry their own malpractice insurance. Many maintain an independent place of business, investing in facilities, equipment, and supplies. And of key importance, independent contractors set their own schedule. They offer their services to other businesses, so they're not exclusively engaged. And they're free to refuse work offers from the public or from other entities. just because you sign an independent contractor agreement and a practice pays you without withholdings and reports the payments to you on a 1099, that does not establish a bona fide independent contractor arrangement or relationship. An employer-employee relationship may exist if your employer chooses when, where, and how you perform your services, if they provide facilities, equipment, tools, and supplies, if they directly supervise your services, establish the hours of work or patient schedule for your services, if they require exclusivity, evaluate job performance, require prior permission for absences, or have the right to hire and fire. This will be an employment relationship and not an independent contractor relationship, no matter how it's labeled in a contract. So to quickly summarize the key differences and why it matters, oftentimes an employer or a practice will prefer to classify a professional as an independent contractor as opposed to an employee. Why? It's less expensive. They save payroll taxes. They don't have to pay workers' compensation insurance for independent contractors. And as a result, the government oftentimes will audit employers to verify that employees are appropriately classified as employees and independent contractors are not misclassified employees. There is liability for employers who misclassify employees as independent contractors in order to achieve the savings. And this is important for all of you to know, because that liability and the costs associated with that employer liability can be shifted to the associate. So if you are presented with an independent contractor agreement, it's very important to analyze that agreement and make sure that there is no language there making the independent contractor responsible for any penalties, sanctions, fines that may be assessed by New York State Department of Taxation or Finance or Department of Labor if there's an audit and a determination that the independent contractor should have been classified as an employee. Just to summarize, employees' income is reported on a W-2. They can be part-time or full-time, and their compensation is subject to employer withholding. Independent contractors are self-employed. Their income is reported on 1099s. They do not receive any fringe benefits. They often have multiple engagements, and they perform their professional services in the time and manner of their choosing.
I have
Moving
a
on to the
question
yes.
Before we go on.
Sure.
If everyone wants to answer this question, I'll close it in just about 5 seconds. All right. Looks like just about everyone is in. I'm going to end the poll. And looks like everyone did well.
Moving on to items to look for. We touched upon compliance with the Stark and anti-kickback statutes, and I want to explain a little bit more about what these are, what the compliance requirements are, and what the purpose of these statutes is. All professional service contracts for healthcare, where professional services may be reimbursed in whole or in part through state or federal dollars, must comply with the requirements of Stark law, also known as the physician self-referral law, as well as anti-kickback statutes. New York State has its own anti-kickback statute, but there is a federal anti-kickback statute as well. The anti-kickback statute prohibits offering, paying, soliciting, or receiving anything of value to induce or reward referrals or generate federal healthcare program business. Just to quickly summarize, these statutes are laws that were enacted to ensure that referrals for healthcare services are based upon medical necessity and the best interests of patients rather than the financial motives of healthcare professionals and practices. These are laws that aim to protect patients. The presence, a healthcare contract that complies with the requirements of Stark and anti-kickback statutes, I'm always happy to see these requirements being met. It typically indicates that a healthcare attorney prepared the contract, and these are both requirements as well as best practices. So let's jump into what these requirements are. The first one's really easy. And if you've been presented with a written contract, then that first requirement is close to being satisfied. Professional services agreements should be written agreements signed by both parties. So don't hesitate to ask for a written contract. It's not uncommon for dentists to be providing professional services without a written contract, and that's a compliance concern. Aside from the obvious that having a written contract, an appropriate contract, can go a long way to protect both the individual as well as the practice. Another interesting aspect of healthcare professional service agreements is that they must have a minimum term, and by the word term here, we mean duration, of 1 year. And there's a specific reason for that, and it's to prevent abusive practices and ensure that the terms of an agreement can't be adjusted periodically or superseded to take into account the value of referrals or business between the parties simply by scrapping one agreement and replacing it with a new one. So a compliant contract not only will have a minimum term of 1 year, but it will have a specific provision that says if the parties terminate this agreement within its first 12 months, they may not enter into the same or similar arrangement until the initial 12-month period has lapsed. So that's an example of a safe harbor compliance provision that hopefully you'll see in a contract. Another requirement is that compensation be specified. The aggregate payments should be specified and set in advance so that the total compensation to be paid over the term is determined at the outset of the arrangement. Now, the specific dollar amount might not be ascertained, and we'll get into this in a little bit of greater detail later, but if there's a clear-cut formula, for example, a base salary plus some productivity component, and that formula does not take into account the value of any referrals, that's acceptable. Other requirements are that compensation must be fair market reasonable, fair market value, and determined through arm's length negotiations. This is another example of safe harbor language, which you will hope to see within professional service agreements, a clear statement that the compensation or remuneration payable hereunder is fair market value and has been established through arm's length negotiations between the parties. The next one seems obvious, but it benefits you not just from a compliance standpoint, and that is that the agreement must clearly set forth the specific and exact services that are required to be performed. As I mentioned before, compensation cannot in any way be determined in a manner that takes into account the volume or value of referrals, actual or anticipated referrals. There should be one contract. There cannot be multiple overlapping contracts as an effort to circumvent the 1 year rule. And the underlying arrangement and relationship must serve a commercially reasonable business purpose. Fairness, we touched on briefly. A fair agreement responds to both the reasonable concerns of the employer and the employee in a balanced manner. Some characteristics of a fair contracts include shared risk and reward between the parties, mutuality and reciprocity of provisions. And we'll get into some examples of mutuality and reciprocity. But an obvious one is if the employer is requiring indemnification by the dental associate, you should ask for indemnification by the employer as well. And lastly, overall reasonableness. And this is a little bit subjective, but any of us is capable of identifying a contractual provision or term that's unreasonable. You will experience discomfort as you read it and consider it. Review by counsel. Again, it's common sense, but it's incredible how frequently it's skipped over. Not just with respect to professional service agreements, but any legal document should be reviewed by counsel before you sign it. It is a good idea to advise your prospective employer that you will have your contract reviewed by your attorney. It's appropriate. This is standard operating procedure. You shouldn't worry about an employer being offended by it. It shows that you are conscientious and appreciate the gravity of entering into a legal contract. So I would not be shy about letting the employer know that. And that also helps manage expectations as far as timeframes. No employer should expect to hand you a contract and for you to sign it right away. There's a process involved, and it's completely reasonable to seek feedback from an expert before you enter into that contract. As I mentioned before, I'm not recommending any particular attorney. I recommend an attorney that has experience and competence in healthcare. And as I touched on before, don't sign any contract under pressure, and never sign an agreement that contains terms that you do not intend to adhere to. This slide represents a tool that I hope will be useful to you. And it's not an exhaustive list, but this is a quick summary of really key terms that you should look for and identify when you receive a contract. I started with restrictive covenant because that's the one everyone knows. And if you receive a contract that does not contain a restrictive covenant, that's outstanding. It's one less thing to be concerned about. But they are standard. Provisions related to early termination are important to analyze. Can both parties terminate early? What are the impacts of early termination? Purchase option. Many practices and professionals in hiring associates, they may be looking at their eventual exit strategy. They may be looking to cultivate an eventual buyer as opposed to just bringing on another professional into the practice. So if you are interested in being an owner one day or a partner, it's a totally reasonable thing to ask about. Will there be any partnership option or purchase option? Fringe benefits. If you're looking at an independent contractor agreement, you will not see any. If you're an employee looking at an employment agreement, it's important to evaluate the fringe benefits. These are items of value that are provided by the employer that are separate from payment of compensation. Sanctions. Sanctions might be buried in different places in the contract. Some contracts have no sanctions. By sanctions, what I mean is any term or provision in the contract that may create a cost to the employee. And by cost, I mean you having to reach into your pocket and pay for something, or potentially pay the employer for some reason in the contract. I don't like sanctions. It's important to identify them and remove them if possible, or modify them. Force majeure clauses. We're seeing force majeure clauses more and more as a result of the pandemic. within professional service agreements. They were not common before. This is also known as an act of God provision. Arbitration clauses. Arbitration clauses determine the manner of dispute resolution if there's a breach or any legal conflict with the contract. Indemnification is holding the other party harmless and defending them from any claim. And lastly, insurance. Your contract will contain specific provisions regarding insurance. It's very important to analyze those with respect to what type of insurance, who is paying it, and does it have retroactivity for prior acts? In other words, is it occurrence malpractice insurance, or is it claims made insurance? If it's claims made, at some point in time, you will need tail coverage, and who pays for that is something that the contract will be able to answer.
We have one more poll question here. Couple more seconds and I'm going to close the poll. All right, Matthew, how'd they do?
Everybody's doing well. That question comes up from time to time based upon reticence or concern about alienating a prospective employer. But I really don't think professionals should have that concern. I think in many respects, it should be reassuring to an employer that the employee is conscientious enough to have an attorney review the contract. So moving into restrictive covenants. This is a broad general term, restrictive covenant, or it's a term of art, and that includes non-compete provisions. It includes non-solicitation language. There are some interesting notions about restrictive covenants. Some people think that they're just not enforceable at all. I can appreciate that people find them offensive or upsetting. They are enforceable. Not all of them are. Enforceability is predicated on the restrictive covenant being appropriately drafted. And restrictive covenants have to be tailored to the particular engagement and location. The law requires that they be reasonable, both in temporal and geographic scope. Typical reasonable timeframes are 2 years. Geographic scope varies wildly. In Manhattan, we're talking about blocks, city blocks. In more rural parts of the state, we may be talking about a geographic area of a 30-mile radius around the office. And that's why, again, these covenants have to be carefully tailored in order to be enforceable. So the takeaways are properly drafted restrictive covenants are enforceable, and properly drafted restrictive covenants that are flawed, okay, for example, overly broad, geographically, or too long, if they're properly drafted, they won't be removed or stricken. They'll actually be reduced in scope in order to be enforceable. So it's unwise to look at a restrictive covenant and dismiss it out of hand and say, "This, I don't have to worry about this, it's not enforceable." I assure you there's always a cost to defending an enforcement action. And I recommend assuming that a restrictive covenant would be enforced against you. Other recommendations, and you'll notice certain italicized sections throughout the presentation are key recommendations I want to call your attention to. Employers are not eager to give up their restrictive covenants. They are reasonable protections for practices. However, something that I'm oftentimes successful in is delaying the efficacy or impact of a restrictive covenant. So for example, if an associate dentist is being hired into a practice and the practice has the right to end that relationship, let's say after a probationary period, 90 days. It seems patently unfair that that associate dentist, after the relationship didn't work out and his or her employment is terminated after 90 days, should be precluded for 1 or 2 years from practicing within 20 miles of that office, particularly when, after having spent only 90 days there, it would be really impossible for them to have developed a patient following or pose any competitive threat against the practice. So one of my recommendations is to try and seek a delay of the application of the restrictive covenant until year 2, when you likely will become a potential threat and have developed a patient following. I mentioned focusing on early termination language. There are 2 principal types or classes of termination in contracts. We're all familiar with involuntary termination. That's also known as a termination for cause. Obvious bases for cause are death of the dentist, loss of license, conviction of a crime, loss of malpractice coverage, or a breach of the contract. These are all terminations for cause, also known as involuntary terminations. In other words, it happened really against both parties' will, or at least one party's will. Voluntary termination is a permissive termination. It's not for cause. And I think it's healthy and helpful to include voluntary termination provisions in the contracts. If the parties are not happy working together, they should have options. They shouldn't be stuck in a multi-year agreement that doesn't have an out for either party. So I oftentimes recommend or will propose a voluntary termination provision, and it often will read something like, upon 90 days written notice from one party to the other, either party hereto may terminate this agreement for any or no reason whatsoever. And what that does is it provides a reasonable period of notice. And the other key thing that I hope you heard there is that it should be mutual. It should be that either party has the right to terminate. Frequently, you'll see voluntary termination provisions that benefit only the employer, or those notice periods may be mismatched. Perhaps the employer only needs to give 2 weeks notice to voluntarily terminate the contract. But if the employee wants to give voluntary notice and end the relationship for no reason, they might have to give 3 months notice or 6 months notice. So these are key things to look for. Another recommendation I have with respect to involuntary terminations is to include the opportunity for a cure for any breach. So for example, if there's an alleged breach of the agreement that is going to be a basis for termination, there should be a requirement or language that requires the non-breaching party to notify the alleged breaching party of what the problem is and give them a certain number of days to cure that. If they fail to cure the breach within that period of time, then the contract can be terminated. Lastly, with respect to involuntary termination and bases for cause, it's important to analyze those specific bases and make sure that they're not ambiguous or general. Sometimes within this list of bases, death, loss of license, conviction, you may find something along the lines of fails to satisfy the employer's reasonable expectations. That's a lot more general and subjective than death. Purchase option, as I mentioned, many practices are looking for potential successors when hiring associate dentists. Future buyers can be found or cultivated. Consider requesting provisions requiring the parties to discuss or create a pathway to partnership after a certain period of years. Note that specific purchase option terms are typically not included in professional service agreements. Fringe benefits. Employees receive fringe benefits, which can include payment or reimbursement of your professional dues, malpractice insurance, paid vacation, health insurance, pension or 401k participation, continuing education reimbursements, and sometimes a signing bonus. Fringe benefits are one area of your contract that may very well be negotiable. One of the considerations, though, is that practices will want to be consistent and uniform about the fringe benefits that they offer to all of their professionals. This is something that you should really be on the lookout for in your contracts. Health payer audits are a significant feature of practice in this day and age. And what that means is all of the claims and medical records that support those claims, which allow for submission of claims and reimbursement by health plans, are all subject to audit by those health plans. And those plans do audit for compliance purposes, but also to pad their bottom line. They know that no records are absolutely perfect. So why is this important? Increasingly, I see provisions in professional service agreements that effectively state if the practice is audited and if any health plan demands reimbursement, alleging overpayments or improper payments because of claims or records that the associate prepared, then compensation can be clawed back from the associate in order to pay that health plan back. So these are troubling for lots of reasons. If you find one in your contract, the practice is not going to be keen on removing it, but oftentimes we're successful in modifying them and limiting a clawback to, to willful or grossly negligent preparation of records or claims, or limiting it to outright fraud or abusive practices. And that narrows it. My recommendation again is that these provisions should be tailored to minimize the risk to the associate whenever possible. I touched on sanctions before, and a sanction is anything that would mandate an offset to compensation or repayments or payments by the employee to the employer. It seems obvious, but we just want the dollars to flow in one direction from the employer to the employee. But some contracts have language that in the event of a breach, in the event of a failure to provide adequate notice before you resign, or failure to timely complete your charts, result in financial sanctions and having to pay the employer. Obviously, violating your restrictive covenant can create significant costs as well. Whenever possible, language obligating payments by the employee to the employer should be removed. I want to touch on the basis for sanctions, why we see them. I mean, in a nutshell, they're there oftentimes because an employer has been burned. But the fact is, any practice makes significant investment in an associate dentist, and they may not recoup that investment quickly. And a premature departure not only stings, but it creates a cost that has not been recovered. So the risk and reward should be balanced between the parties. And I really want you to remember this very clearly. Avoid any employment agreement that includes a promissory note as an attachment. I see this from time to time. A promissory note is a legal instrument that is a highly enforceable obligation to make a payment. If there's a provision in the contract that says you have to pay the employer a certain sum upon the happening of a certain event, you can argue about that. You can go into a court, you can raise defenses. With a promissory note, it eliminates the opportunity generally to raise defenses and creates an enforceable repayment obligation. If you see them as part of a contract, I don't recommend signing it. Force majeure clauses. These are typical in supply, construction, vendor, and other service agreements. As I mentioned, they're creeping into professional service agreements as a result of the pandemic, and it allows either party to suspend performance as a result of impossibility emanating from circumstances beyond that party's control. Arbitration clauses provide that dispute resolution be constrained to binding mediation or arbitration, as opposed to judicial review and litigation in a public forum. Arbitration clauses typically favor the employer because they add privacy to dispute resolution. An arbitration clause forces any legal dispute to be settled in accordance with its terms. And the exception is often with respect to enforcing restrictive covenants, because that requires injunctive relief, and only a court can issue injunctive relief. Indemnification provisions shift liability and require a party to hold the other party harmless. These provisions often hold the employer harmless and require the employee to defend claims made against the employer for any prior acts by the employee or any suits or claims that are not covered by malpractice insurance. Make sure you have mutual indemnification if it's only present for the employer. Insurance. Your malpractice insurance should be provided by or reimbursed by your employer and expressly described in the contract. It will either be on an occurrence basis or claims made. As I mentioned, if it's claims made, you'll require a tail if you change policies, or often upon the termination of the contract. Employers frequently shift the cost of tail coverage to the associate. You should ask the employer to cover the cost of tail insurance in all circumstances. And if they're resistant to that, I would push that your tail policy be covered if you have provided a certain number of years of service to the practice. I think that's a reasonable compromise. Term and termination, term being duration. Again, we're looking at contracts that are a minimum term of 1 year. Consider auto-renewing. Contracts can have language that they do not have any specific expiration date. Contracts that renew automatically, we refer to as evergreen contracts. They can still be terminated, but they renew without any action by either party, and this avoids any gap in a contract. Seek mutual voluntary termination on equal terms and adequate notice from the employer, and commit to providing also adequate notice if you're going to resign. As I mentioned, I want you to analyze the bases for involuntary termination, make sure they're reasonable. Are there any ambiguous or general conditions that might easily allow you to be terminated for cause? Is there a notice requirement and an opportunity to cure a breach before you're terminated? Do you have an involuntary termination provision? And what additional rights might this grant to you? The services should be clearly defined in the scope of employment. And those details should include the locations that you're serving at, your responsibilities, whether there's any call coverage, as well as whether the engagement is exclusive or permits any moonlighting or any authorized outside professional services. There should be language with respect to the dental records that you'll be preparing. They almost always belong to the employer, but you should make sure that there's language present that permits your post-employment access to the records for specific lawful purposes, like defending litigation, responding to an audit, pursuing a fellowship or similar board requirements, or based on authorization from the patient. Take a look to make sure you can comply with specific timeframes for preparing charts, and take note of any financial penalties for any failure to timely complete dental records. Compensation can come in different forms. It can be fixed as a base salary. You may be paid on commission based upon your productivity or based on collections, reimbursement for your productivity. Or it can be blended with a base and a productivity-based incentive component. I always recommend having some base because it's a guaranteed payment. When you're paid based upon collections, you're always going to be paid in arrears. Productivity can also create a delay in payment, as well as estimated payments. And the problem with estimated payments is it can result in an underpayment or an overpayment to the employee and force a reconciliation between the parties. Compensation must be fair market value. If you have an evergreen contract, I recommend seeking escalation for those renewal terms, escalation in the compensation. Productivity can be tiered. There can be a certain percentage of collections above a certain threshold, and if productivity is significantly higher than that, a higher percentage can be provided or offered if those higher benchmarks are met. An additional benefit related to compensation or net income, maybe if you're working in a designated hospital or clinic that allows for loan forgiveness or loan repayment. That's something to inquire about. It's very important to address outside professional income. This can be addressed within the contract. Outside income that is non-competitive should be retained by the employee. Most employment contracts require exclusive service, and they state that all professional income is assigned to the employer. So it's really important to specify what non-competitive income you get to retain within the contract. And examples include publishing, speaking, expert testimony, chart review, or volunteer work. It's critical to negotiate these terms before signing the contract. Last piece of compensation, a signing bonus or relocation payment. This is oftentimes offered in private practice, frequently when relocation is necessary. It's oftentimes subject to repayment. If you receive a sign-on bonus and then you terminate early, you should expect to have to repay all or some of that. But repayment obligations should be pro rata and not subject to any interest. I just want to wrap this up with items and terms that you should absolutely avoid before we move on to questions. If at all possible, avoid acquiring a restrictive covenant. It maintains your options. Liquidated damages are financial penalties. Avoid contracts or seek to strike provisions that describe liquidated damages. Repayment obligations like clawbacks from audits, promissory notes, and any illegal terms, including compensation for referrals, kickbacks, or improper fee splitting. I'd like to pause and take any questions that we have so far.
Awesome. So our first question, can you be classified as an independent contractor if you work solely at one practice?
The answer is yes, and it's a good question. There are other elements that establish a bona fide independent contractor relationship. It is not a requirement that an independent contractor serve multiple hiring parties. So the answer to that question is yes.
Okay, our next question. How can you tell if temporal and geographic scope is reasonable? Will legal counsel be able to advise on this? Is restrictive covenants negotiable at all?
Okay, great. Great questions, three-part question. This is a question I'm asked frequently. Is it reasonable? And I have to be familiar with what is reasonable in different geographic areas throughout the state. So your attorney should be able to give you a sense of whether or not it is reasonable both in temporal and geographic scope. If it's longer than 2 years, and we're not talking about a retirement or withdrawal from practice, it's probably temporally unreasonable, maybe unreasonable. But again, geographic restriction can vary wildly. The last part of this question is, are restrictive covenants negotiable? Often. The example I gave you of a new dentist joining a practice, being subject to a restrictive covenant, and then deciding that they don't like him or her early on and cutting them loose. It just seems so unfair that that professional be burdened by that restrictive covenant. In negotiating contracts, most practices and employers are protective of their agreements. They want them to be standardized, and they're not keen on making changes. But all of us are keen on making improvements. And I've often found it helpful to review these concepts in the context of fairness. So simply presenting the scenario that I've presented to all of you, I have done countless times to practices or other attorneys, where I say, what if your client decides that you don't like my client and they cut her loose, after 90 days, and then she's got to leave the town to go and practice at the next town over. That doesn't seem fair. And sometimes we're able to revise that restrictive covenant, again, not to be applicable in the first year, or not to be applicable. This is another thing that I do, that the restrictive covenant will have no force or effect if the practice voluntarily terminates her. In other words, if they terminate my client for any or no reason during the first year, not for cause, not because they've done something wrong, it's unfair to burden them with the restrictive covenant. So yes, they are negotiable, but not always.
All right, great. We had a few more come in. So if early termination occurs, does the restrictive covenant still go in effect?
It depends. Typically, yes. Okay. Typically, yes. Typically, a restrictive covenant is effective and enforceable upon any expiration or termination of the agreement. And that's where we want to parse those details. Instead of taking a hatchet to the agreement, take a scalpel and say, all right, well, I understand you need to have this restrictive covenant for your comfort and to protect your legitimate business interests. But let's tweak it a little bit and make it a little bit more fair to both parties, respecting your need for protection, but also respecting the fact that my client is at the beginning of his or her career and shouldn't have all of their options foreclosed if this opportunity doesn't work out.
Thank you. For residents who are soon to graduate, at which point in our career would you recommend becoming an independent contractor? Is it worth delaying becoming a PC for the purpose of acquiring fringe benefits?
That's a really interesting question. I think, said another way, it is, am I better off becoming an employee or hanging up my own shingle, right? There's something about being an independent contractor that affords greater freedom. You are self-employed, you have your own entity, you can work with your accountant on what legitimate expenses you can run through your own PC or PLLC, what deductions you may be able to take. Those are things that you've got greater opportunity to do as an independent contractor in business for yourself. It's hard to say what is better, what is more advantageous. So I'm going to give you a Solomon-like answer to this question, which is you can do both. You can be an employee, and there's nothing stopping you from also forming your own PC or PLLC. And as long as using that in practice doesn't conflict with the terms of your employment agreement, if your employment agreement doesn't mandate exclusivity, and it may not, there's nothing stopping you from also having engagements as an independent contractor. You'll need to have separate insurance, your employer may need to authorize it, or the contract needs to permit it, but you can really do both of these things at the same time.
Great. So we have 2 more questions before we end. What is an expected legal fee to consult an attorney for a contract?
Oh, this varies as much as restrictive covenants. It varies a lot with geography. We do a lot of work with NISDA members, and we have a special rate structure for NISDA members who participate in your legal plan that is highly competitive. Our office is based we practice throughout the state, and we have offices throughout the state, which is part of how we keep tabs on what different rates are in different parts of the state. I have peers who charge $800 an hour, $500 an hour for exactly the same work that we do. We don't charge rates like that. So I think a reasonable spectrum of rates that you should anticipate encountering when you're speaking with competent healthcare professionals, healthcare attorneys, may range anywhere from $200 an hour to $800 an hour.
Thank you very much. And the last question is restrictive covenants common for part-time job contracts as well?
That's a good question. And it really depends on the employer, but I'm going to say generally yes, because even in a part-time engagement, that employer has the same interests and concerns as a full-time employer. They want to protect their staff from being poached. They want to protect their patient population from being diverted. And they want to make sure that a superstar part-time dentist who comes into the office 2 days a week and who the staff loves and who patients love doesn't have the ability to open up next door or across the street and negatively impact that practice. So just because it's a part-time engagement, I would not expect not to see a restrictive covenant. But if you're looking at a part-time contract and there is a restrictive covenant, there's nothing to stop you from saying, is this really necessary, particularly in my part-time contract? I expect the answer will be yes, but it's a reasonable question.
Thank you so much. I'm going to launch the evaluation questions. So please fill out the evaluation, answer the 3 questions, and that is how you will receive your CE certificate. We want to thank Attorney Matthew Feldman for joining us tonight. This was extremely helpful. Lots of really awesome questions. We are recording the webinar, so we will have this available on demand. We will also be sending out your tip sheet in the next couple of days. And please don't forget to register for all of our future Survival Guide series webinars over the next couple months.
In closing, I just want to thank everyone for attending. And I also want to encourage you, if you have any follow-up questions or any question that you didn't have the opportunity to ask tonight, please don't hesitate to contact me by email. I'd be happy to respond offline.